Good morning. Happy Wednesday morning, June 26th, and welcome to the day that everybody is on the edge of their seats waiting for the jury to come back from deliberations on the Karen Read trial. I covered this trial on Friday evening. I gave a recap of the Commonwealth's case, the state, if you will, or the Commonwealth, the prosecution's case against Karen Read, who has been accused of unaliving her, at the time, serious boyfriend, John O'Keefe, with her car in Canton, Massachusetts, back in 2022, on the overnight between January 28th and January 29th, in the super early morning, like midnight hour of January 29th. So we've heard the Commonwealth's case, which I did a recap of. Hi Zara, hi Crystal. We also, and so that's the recap that I did on Friday. And then now we have completed the defense's case, which was remarkably short. Oh yeah, slushy. I've had enough problems with insomnia. I am not going to be to blame for, no, I'm kidding. But if you can get to sleep, go for it, slushy. But yeah, so I'm here today, essentially, to recap the defense case, recap the closing arguments that we heard yesterday, and see who wants to participate in a little bit of a jury deliberation, if we have time. But I have time today, let me just say. I'm going to keep my eye open on, I'm going to have another tab open to YouTube just to see if I can get a, one of the, maybe Court TV, because I just want to see when, everybody's on verdict watch today. So this is what happened. Yesterday, the whole day was, first of all, there was like an hour of delay because there was a juror problem and the juror had to ultimately be excused. And then the jury went to deliberations. Then they gave their closing arguments. Each side got 1 hour. The judge was pretty strict on that, gave them 5-minute warnings on when to end their closing arguments. And then she gave the jury instructions, and then the jury went to deliberation. I think they left for deliberation around 1:20 something in the afternoon. And I believe that their court day ends at 4 or 5 p.m. They weren't back by then. So they're at about 3 hours of deliberation time, which is not a very long time, depending on how they want to do it. Yes, Zara. The closing arguments were wild. Yes, especially the contrast between the two. And I think really the contrast between the two closing arguments really well demonstrates the contrast between the two cases, essentially, throughout this whole case. The defense didn't have to prove a theory of what they think happened that night. The defense's job is only to say, did the state or the Commonwealth, did the prosecution really prove their theory to you, jury, beyond a reasonable doubt? Here's all the reasonable doubts. Here's all the reasons why the Commonwealth did not prove this case. But they went above and beyond. They did more, they did the most. They very neatly knit together an exact timeline of what they believe happened, which was not Karen Read hitting John O'Keefe with her car. So, let's go in order. I'm going to be as quick as I can on recaps. This is a chart I made last time of the relationships between all the people. I highly recommend, if you're brand new to this case, this is not going to be a great stream for you to jump in on. I recommend that you go back and watch my previous one first before you watch this one. Also, I'll recommend like this stream. It helps people see it. Subscribe to my channel if you like my content. Set your notifications to all because I'm primarily streaming these days, and I definitely have a stream plan for this Friday. There's a story I've been following that I need to yell about. So let's go with, I'm going to recap the defense case. I'm going to recap closing arguments to an extent. And then let's have just like a little mini internet jury here today. Jury? Who am I? I've been listening to too much Boston. My Connecticut is going away. Okay. Okay, so I have a couple of notes. So the defense case started on what's today? Today's Wednesday. So the defense case started being presented on Friday afternoon, and then they had the weekend, and then all day Monday was the remainder of the defense case. Basically, because the defense had, and this is typical, defense cases usually don't provide as many witnesses as the prosecution because they have the whole prosecution case. However long their case is, that's also opportunity for the defense to start presenting their case through the process of cross-examination. So they've already made a ton of points by the time they get to the defense's case in chief. So oh, hi, thank you guys. You're so sweet. I'm happy to catch you guys live as well. Let me know if this time works because I really like mornings. I'm a morning girl. Okay. So the defense only brought 6 witnesses for their case in chief. The first witness they brought was a plow driver named Lucky Lofgren. He was plowing that night. We've heard 1,000 times about the snow and about the blizzard that was happening that overnight between Friday the 28th and Saturday the 29th. And it really was picking up speed in those very early morning hours of the 29th. So Lucky Lofgren was assigned to start plowing at 2:30 in the morning. And he drove this big giant truck called Truck or Frankenstein, which basically is like a very souped up plow truck. It has a lot of attachments, basically, so that's why it's a Franken. So he's the one who was assigned to plow the road, the 34 Fairview Road, which is the road where the house... Hi. He was assigned to plow Fairview Road and that neighborhood. And we know that John's body was found on the front lawn of 34 Fairview Road, the home of the Alberts, who are a police family. Have fun interpreting this. I promise it made more sense when I explained it. But also if you need, I can go through this again. So he gets started plowing around 2:30 in the morning. He's very attentive while he's plowing because he doesn't want to hit any animals that might jump into the road, any people who are out and about. It's a Friday night into a Saturday. People are out having fun. And basically the crux of his testimony is he drove by and plowed by the Albert's home on 34 Fairview Road around 2:45 in the morning. He did not see anybody lying on the lawn the first time he went past. He came back and plowed back again around 3:30 in the morning, I think doing the opposite side of the road. And I believe that then he also did not see anybody. Oh, no. Okay, so there were 3 passes that he made. I think that first pass at around 2:45, he didn't see anybody. Came back around 3:30, and I think what happened was he saw a Ford Edge that now was parked on the side of the road in front of, and we're going to talk about this, the report that was written, because Lucky eventually was talked to by Michael Proctor. There was a Proctor report that was written about Lucky's plowing that morning, and the prosecution really tried to discredit Lucky by saying, the report about this doesn't match what you are saying now. The report says that you went by at midnight and 2:30, not that you went by at 2:30 and 3:30 and 6:30. And he's like, well, this is what my story has always been. And in my mind, as soon as I know that a report is written by Proctor, I'm not going to trust the report over the person, you know? Like that's just where I'm at as a internet jury member, juror number 13 over here. That's just my personal thoughts on that. So he drove by the home 3 times, or went to. The first time he was able to plow, he didn't see anybody on the lawn. The second time he came back through, there was a Ford Edge parked on the side of the road, like kind of right in his plow path, and he had to move around that Ford Edge as he plowed. And in the report, it is written that where the Ford Edge was parked is essentially right in front of where the body was later found. I don't think that that's something that Lucky said. I think that that's something that like Lucky described where the car was, and then the report writer, Proctor, made the connection that where he says the car was parked is right in front of where John O'Keefe was found. I don't think that that's what Lucky said, my opinion. So, and then the third time Lucky came to come down the street and plow again was around 3 hours later, around 6:30 in the morning. And at that time, everything had started happening. There were paramedics, there were ambulances on the road. He basically couldn't get down the road, and so he didn't end up doing that final plow pass. And there was some confusion about whether that was happening at 5:30 or at 6:30, but the fact of the matter is, like, we know from all the timeline that we have experienced thus far in this trial, it must have been 6:30, because nobody was out in front of the Alberts house at 5:30, certainly not ambulances. 5:30 is when they were still at home, and like Karen Reed was like just waking up and discovering that John had never come home, and she was just starting to like call Jen, call Carrie Roberts, ask for help. They were just leaving to go look for him, and then they found him at 6:03 a.m. in the Alberts lawn. So it doesn't make sense that there would have been paramedics there at 5:30 when he was not found until 6:03. So I don't like it when Lally was crossing this guy, and I get that it's for the purposes of discrediting him as a witness, which he's allowed to do. But when Lally is cross-examining this guy and saying, well, what you said was 5:30. You said it was 5:30, and we know that what he's saying doesn't line up with his own facts that he has presented to the jury. Like, this is the thing. There's so many plot holes in Lally's story. And what I've noticed a lot about lawyers, as I've watched a few trials now, I'm a bit of a LawTube fan. Although, speaking of which, I forgot to say, this is all my opinion. This is my speculation. I'm not a lawyer. I'm not a doctor. I'm not a police. I'm just a person at home in my room, giving my opinion. And that's the point of this. I'm here to be a non-informed juror experiencing this case and giving you a place to do that as a juror instead of, it's nice, when you're looking for legal commentary, it's great to have the lawyer's opinions while you're watching the trial. But when you're just trying to watch the trial from a kind of pure place and just see what happens, it does infiltrate, the lawyer's points of view. So I would be a place to experience learning about this trial as a juror from a juror's point of view, as a, LawTube watcher, lurker, not a informed person, but at least not professionally. So I've watched probably 4 full trials, 1, 2, 3, 4 full trials, or 5 play out in court, and there's such a difference in confidence, there's such a difference in defensiveness between the lawyer who feels like they've got it and they know that they're right versus the lawyer who feels like they're fighting an uphill battle to prove their case. Lally this whole time has been the lawyer who's fighting an uphill battle to prove his case, and that should not be how a prosecutor is behaving. And that's the kind of like throwing up dust, like the way that he was when he was questioning Lucky and saying, well, but you said it was 5:30, even though like he knows that there's no way it could have been 5:30 because we know that that's not when the ambulances got there. But you said there were ambulances there at 5:30, so, and like, you know, smoke and mirrors. What's the point? Why would you do that? It makes you look so unconfident and unbelievable. So I don't like that kind of stuff, and it's not a good sign coming from the prosecution, in my opinion. So anyway, that was the testimony of Lucky, the plow driver. That was on Friday afternoon. Let me check in with the chat here real quick. Yeah, can't trust it if Proctor touched it. That's not where I want to be, but that is where I am because those tests. Okay, next up, there was a medical expert named Dr. Russell, who, there was a voir dire on her. I did watch the voir dire as well, which I shouldn't have done to do a pure jury experience, but I was a little bit in withdrawal from having no court to watch. So, and just in case she wasn't allowed to testify, I wanted to see. So, Dr. Russell is an incredibly experienced ER doctor. She's a medical expert in this case. She has decades of experience, and she specifically has studied dog bites a lot. And has written reports, like scholarly articles and journals about dog bites. So she was brought in by the defense to opine on whether or not the marks on John O'Keefe's arm look like they came from dog bites. Long story short, her opinion is yes, definitely. So there's really just not much else to say about it besides that. It was short, sweet, to the point, and she's so experienced and so professional, and I'm glad that they had her to bring in. Next up that day, they had a tech expert named Dr. Green. He was a tech expert and phone expert. Again, decades of experience since like the 90s. I'm very frustrated by the phone tech testimony in this case, and I feel like I think I had my mic facing the wrong way this whole time. Does the sound suddenly sound much better? I'm embarrassed. I'm so sorry. Let me know if this suddenly sounds better. Oh my God, guys, I'm so sorry. Thank you. Okay, now we have sound quality back. Hi, I had my mic facing the wrong direction because I set up in a rush. Okay, cool. So this is such a good point about Lucky Loughran, the plow driver, in terms of like, who am I going to trust? Talking Bones, especially because he's just a random man plowing the street. He probably didn't remember the exact time that he passed the street 2 years ago. It's such a non-point to focus on a specific time like that. I agree. It feels like smoke and mirrors that are just unnecessary. But you know what I'm noticing, like what made me pull this comment up is he's just a random man plowing the street. Lucky Loughran, if anything, has no investment in how this case turns out. If anything, honestly, he's grown up being cordial and friendly with the Albert family. So one might expect him to side with them and to participate in whatever cover-up they feel like might have taken place. But he's just an honest guy who's there to tell the truth, and that's what he did. You know, even at the expense of probably angering some people that he's been friends with since elementary school. He's known the Alberts since elementary school. But he still got up there and said, yeah, I didn't see a body on the lawn. And then, you know, these time periods. And he doesn't know the whole scope of the case, so he doesn't need to know, you know? So he might not realize the impact that his testimony has. But it does. It makes a big difference in the overall timeline. Yes. He literally worked for Chris Albert delivering pizza for years. Yes. So he could be Like, he could have chosen to be biased toward the Alberts, but he didn't. Or he might not even know. He might not even know that what he's saying makes the Alberts look bad. He shouldn't know, because he shouldn't be watching the case. So we'll see. All right. So anyway, back to the tech experts. I've been very frustrated by the tech phone conversation in this whole experience, because in a way, the defense's conspiracy case, the idea that the Albert family is colluding together to cover everything up, it kind of hinges on this text, or this Google search, by Jen McCabe at 2:27 in the morning. Hoss long to die in cold. The Commonwealth expert said that that was not when the search actually happened, and that it reflected 2:27 a.m. because the tab that search was performed in had been opened for the first time at 2:27 a.m. So that's why it was reflected that way in the report. The tech expert for the defense, Dr. Green, they're both extremely experienced. He said that that's not the case, and that it does look like it happened at or before 2:27 a.m. Because of how it reads in the Celebrite report, and because he did testing on that version of that phone using that iOS version. And that's like, he created essentially duplicated it with his own testing. And like, I feel like these are two extremely experienced, knowledgeable people. Hearing these two conflicting testimonies, what I would like is for the two of them to get together and chat. I'd like to watch that. Like, as a juror, I'm like, this is kind of an important Google search for the defense's case. And it, again, not that the defense has to prove a timeline. They don't have to prove what happened. But there's enough weight that's been put on this Google search by the defense and by the prosecution, essentially defending Jen McCabe from that claim, that it's like, this seems important. I would like to see what happened if these two experts got together and had a conversation, and they could probably within 2 minutes come to whatever is the misunderstanding between the two of them and sort it out like that. But right now, because we can't do that, it's just two conflicting testimonies, both of which were very technical, both of which were a little bit hard to follow. I tried my best. I feel like the Commonwealth's tech expert was a little easier to follow, and I was struggling with Mr. Green. I was, because I'm not a tech person, I'm not. It's certainly not to the level of analyzing multiple reports from Celebrite and Axiom and all these different analyticals. So for me personally, I can only put a question mark on that fact set of like, I don't know when this was searched. I don't know what it means, if anything. That's kind of how I feel about that right now. But ultimately, Dr. Green says that Jen McCabe's "Hoss long to die in cold," incriminating looking Google search, he believes that it took place at 2:27 a.m. or earlier, and the Commonwealth's expert says no, it took place at 6:23 or 24 a.m., which puts it in the timeline of when Jen described during her testimony of when Karen asked her to search that. So, I don't know. Let me know what you think in the chat, because when we were hearing from the Commonwealth's tech expert, somebody in the chat in EDB's chat was saying, like, I work in this field. What she is saying about the tabs is true. But then I was watching during Dr. Green's testimony, and somebody in the chat was agreeing with Dr. Green, saying, I work in this field. Dr. Green is correct. So, like, help. I don't know. I don't know what to make of it. I don't know what to make of it. Okay. So those were the first three: the plow driver, the first medical expert, Dr. Russell, and then the tech phone expert, Dr. Green. That was the end of the day on Friday. Then comes Monday. Yes, Monday. First, we started with medical expert Dr. Sheridan, who's like the most experienced medical examiner anybody has ever met. He's done between 12 and 13,000 autopsies in his career. He's an older gentleman with an expansive career. And his report, his testimony boils down to the injuries on John do not line up with him being hit by a car in the way that the Commonwealth suggests, if at all. Like he's saying it does not look like that. One of the things that he said that I feel like was really helpful to know was that when John was somehow impacted in the back of the head, that knocked him unconscious, and he would not have been able to move after receiving that hit, whatever it was, whether it was a fall, whether it was a hit, whatever it was. So there's no circumstance in which he got hit or he was hit by the car or whatever, and then got up and stumbled a little bit and then fell. So I feel like that's really important for the sake of when you look at where he was in the lawn compared to where the driveway is that Karen Reed was at. And like it makes it a much more narrow, like it really narrows what could have happened for the Commonwealth sequence theory to make any sense. So there's no outs for the Commonwealth, and I feel like it's not lining up. It's not adding up. Dr. Sheridan also opined on the marks on John's arm and said that he also does not believe that those were caused by dog bites. And that's kind of like the sum and substance of his testimony. And he's just so incredibly experienced. The defense's witnesses are so experienced. Decades and decades of specialized experience. Whereas a lot of, the most experienced person that I feel like the Commonwealth put forward was their medical examiner, who said the manner of death could not be determined. She did not feel comfortable committing to the car theory that they brought forward. And the tech expert, who I liked her a lot. I think she's very smart. I think she had some great points. But then Dr. Green completely disagreed with her. So, I don't know. But every single person that the defense brings out is super duper, like the most experienced expert of all the experts, except for the plow driver. But he's an expert in plow driving, essentially. He's got his 10,000 hours doing his plow work. So I feel like that's why they kept the witness list so small. It's because they didn't need much more than that. Let me check in the chat one more time. Yes, you guys are on board with me too. Honestly, the whole house long to dying cold does not matter to me. There is still not enough evidence to convict her. I'm assuming Karen. Yep. That's definitely where I'm leaning, is like, it matters to the defense with the story that they're trying to tell, but it's not the deciding factor on whether Karen hit John with her car. It's a side plot. It's a whole side quest that everybody has been on. Okay, the last two testimonies for the defense were on Monday, and they were from this team of FBI experts. Guys, there's been a whole subplot this whole time that if I was a jury member, truly, I would not know about this at all. But, I've heard through commentary that there's an FBI investigation into this investigation, and I think especially into Michael Proctor. So two experts from the FBI were tasked with reconstructing this event and what happened to John. They gave the FBI guys, the FBI contracted with this company. ARCA is the name of the company. They gave the ARCA guys the evidence that had been collected by the Canton or police or the state police or whoever collected it, and they said, here you go, Here's a box full of evidence. Go see what you think happened. And Dr. Wolf is, his testimony was kind of relegated to the damage to the car, to Karen Reed's SUV, and speaking on that. And Dr. Rentschler is a biomechanic engineer, expert in biomechanics. Dr. Wolf is an accident reconstructionist. Both of them are, though, I think. So, whatever. And then Dr. Rentschler specializes in biomechanics, which is what happens to a body during an event like this. Whereas Dr. Wolf was speaking more about what happens to a vehicle in the alleged pedestrian hit by a car situation that they're describing. So they performed a bunch of testing, just looking at the evidence that they had, and the contrast between what the evidence told them versus what the evidence told Michael Proctor is staggering. Because the theory that they were able to come up with as far as the damage to the taillight, Dr. Wolf was saying we theorized that somebody might have, in this case it would have been John, but that somebody must have thrown the cocktail glass at the taillight, and that's what damaged it, because it looks like there was damage done by a small object, not a human being, not a human arm. And we'll get back to that in a minute, because Lally said something in his closing argument that it was not the win that he thought it was. And we know that nobody is suggesting that John threw the glass at Karen's car. That's not what the Commonwealth is suggesting. The Commonwealth is suggesting that John was holding a glass in his hand. Karen backed into his arm. His right arm, I guess, because it was to the passenger. Okay, so that he was holding the glass. It's going to be mirrored on camera. I'm sorry, guys. It's not going to look on camera the way that it is really. So he was holding the cocktail glass. Karen drove back, hit him in the arm. The impact of that sent him spinning and flying over in this direction, and he tumbled, slid 30 feet to where he laid for his final rest, and in the process hit his head, thus the fractures and the laceration there. So that's not what they even came close to thinking based on the evidence that they had in front of them. And basically, Dr. Wolf said that the damage on the car does not line up with the car hitting a person. And then Dr. Rentschler, the biomechanics guy, was looking at the injuries on John and again saying these injuries do not line up with him being hit by a car in any way, on the arm, on the body, on the anywhere. And he pointed out again that the way that the injuries are, there should have been much more bruising if he was hit by a car, including the scratches on his arm. If he'd been hit by a car and the car caused those scratches because, the tail light came apart and the glass shards scratched him or whatever, still there would have been bruising around that as well. And there was not. There was just the scratch marks or bite marks as the defense is theorizing. So there was a lot of lack of certain things that made it hard for them to, basically impossible for them to come to the conclusion that John was hit by a car. And I'll also say that Dr. Sheridan, the second medical expert who spoke at the beginning of the day on Monday, he also said it was not possible. And those are strong words. Those are strong words to say that something is not possible. We did not hear that kind of dedication that kind of, I don't want to say conviction because it means something different legally, but like that conviction, dare I say, to the Commonwealth's theory from the Commonwealth's people. They were saying, so yeah, it's possible that this might have happened perhaps. And it's like, that's not what you're here to prove. You're here to prove that something happened, you know? So it's like, for the confident people are the people on the defense's side. And what's also extremely interesting about these FBI experts that Alan Jackson pointed out effortlessly, they were not paid by the defense. They were not paid by the Commonwealth. They worked for the FBI for a whole separate reason. And they were available, and their reports were available to both sides, and they would have come in and testified no matter who had asked them to come in. But the state, the Commonwealth, didn't choose to present them and their reports as evidence in this case. And you can't help but wonder why the defense was the one calling them in and why their information would never have been heard had the defense not brought them in. Well, I mean, it's not wondering at this point because now we're in deliberation mode, but yeah, exactly. Gotta admit, I'm jealous of the guy who gets to go full Mythbusters and randomly build a cannon because science. So this is the thing. FBI guy, Mr. Wolf, who was responsible for interpreting the damage to the car. Part of figuring out the theory with throwing the cup, the drinking glass at the car involved, they built a cannon to throw the glass at the taillight to see at what speed they would have to throw it for it to cause the damage that they saw on the taillight. So, cool job. Pretty awesome, I think. And he thinks so too. He said so in court. I'm gonna really quick, because here's the thing, guys. I don't know when, but the jury could come back any moment on this case. Like, it's the morning. It is 9:38 a.m. here on the East Coast. Their day starts at 9. They already had hours of deliberation yesterday. It might even, it might not, they might be back before noon, because I feel like, especially looking at the sentiment that's in the chat right now, people are pretty, hung up on all of the reasonable doubts. And so with that being said, let's go to closing arguments, because those were it. Those were all of the witnesses that the defense called. They did not call Karen Reed, and I feel like they didn't need to. And so did they. So with closing arguments, each side had a big plot hole for me. And I just want to lay this out at the beginning. The defense gave their closing argument first, and then the Commonwealth. The defense was delivered by Alan Jackson. The Commonwealth's closing was delivered by Lally, of course. So after the defense gave their closing statement, the main thing I could think was, if Brian Higgins and Brian Albert killed John, which is what the defense is suggesting, why would they carry him outside and leave him by the curb and still on the Alberts' property? And wouldn't they have worked harder to hide him? That's something that I just I kind of was waiting at some point for somebody to explain, if you're going to go to the effort of taking a body out of your house, wouldn't you take it farther away? That has confused me over time. And I kept kind of waiting for somebody to say something about it. But I will also say, I came to that thought before Lally brought it up in his closing argument. And, Lally, point to Lally for bringing that up among all of the other things that I feel like were not really points. My face is so red. It's hot in here, guys. But so now after Lally's closing argument, and I'm going to get to a summary of the arguments in a second, but After Lally's closing argument, the prosecution's closing argument, my main remaining question was, if Karen, as the Commonwealth suggests, knowingly, purposefully hit John with her car, why would she then drive back to his house to hang out with his kids? That, to me, seems so implausible. Like, if you're that mad, so mad that you hit a person with your car, what do you think is going to happen? You go home to that person's home, like, what, provided you didn't think you killed him, right? That you were just mad and you just hit him to prove a point. What did you think was going to happen when he got back home and found you there? Like, and if you did think that you killed him, wouldn't you be fleeing? Wouldn't you be on your way out of the country? Like, I don't understand how that explains Karen's movements after what they think happened. So both of these questions make me think, among many other things, both of these questions make me think that both theories are wrong. But either way, the Commonwealth is the one with the responsibility to prove a theory, and they have not, in my opinion, to me. So to me, that means that Karen is not guilty. The defense doesn't have to prove their theory, but they came real close, is what I'll say. So let me start with their closing argument. Yeah, okay, thank you guys. Yeah, the jury probably does just want to talk to each other. Yeah, why would she go to his house and then also phone him 53 times? Right. So, oh, yeah. We'll get there, Zara. That's so petty. The prosecution made a couple of petty points. And so, guys, can I just tell you, it's getting a little hot in this room. That's why my face is getting red. So, in keeping with the air conditioning theme of this trial, I'm going to need to turn on my AC, but I will pull the mic closer, so hopefully you don't hear it too bad. Give me just a minute, take a drink of water. I'll be right back. Okay, sorry for the sound effect that you're now about to have for the rest of this, that buzzing. I wish it was quieter. I'm so sorry. So, the defense's closing argument was a comprehensive retelling of the story of what they think happened that night to John O'Keefe, using timestamps, timelines specific down to the minute, and especially because Karen Reed did not testify, Alan Jackson had the opportunity, and I would say the responsibility, to get up there and tell her side of the story, her mindset about why she was doing the things that they're saying that she did. So what they said, they went to the waterfall. Sorry, let me back up. Jackson says that, yes, Karen and John had been having some arguments or whatever, but before they went to the waterfall, earlier in the day on the 28th, they had talked things out, they had made up, and then when they got to the waterfall, all that anybody could talk about was how lovey-dovey and nice and affectionate they seemed to each other, because that was real, because that was how they were feeling. Can you just let me know, is this now actually too loud or too oppressive having my mouth up close to this. I'll watch the chat. So they were at the waterfall. They were having a good time because they were having a good time. They went to go to to the Albert's house as they were invited. Thank you, Talking Bones. Thank you, Slushy. And when they got there, I think what happened, I think what Alan was saying was that John was going to run inside and like check out the party and then come back or something like that. And Karen waited in the car for him to do that. And she started to call him because he was in there for a few minutes and like had forgotten her, is how she felt. And then she, you know, as the minutes passed, she kept getting more irritated because he was like forgetting her essentially. And so to make a point, she left him there and continued to call him. She went to his home, continuing to call him to say, hello, hi, where are you? And I assume that means that had he said, oh, sorry, babe, then she would have drove the 5 minutes back over to pick him up and bring him home. I think that was the point that was trying to be made. So she called him. He wasn't picking up. She texted him. He wasn't responding. She got to John's house, pulled in because the kids were there, and they needed to have someone with them, minors. She sent some messages and some texts saying that she was leaving to go back to her home in Mansfield, but she didn't actually. She stayed at the house. She was trying to bait him to come home and to respond to her. Really, it was more about like, will you please respond to my calls? And then she falls asleep. The night passes, 3-4 hours. She wakes up. She realizes, wait a minute. I haven't heard from John. John has not come home. What's going on? Something serious has happened. And then a panic. And then everything else that we've heard a million times from the defense and the Commonwealth about her behavior, her search with Carrie Roberts and Jen McCabe trying to find John, where they find him, that all happens. But in between there, in that time period of mystery, what the defense is presenting is that Brian Higgins, who had been texting with Karen and who she had stopped texting him because she was over whatever flirtation they were having, he was at the waterfall at the same time that they were. He wanted to make sure that John showed up at the home of Brian Albert that night, came to the party, and what they are presenting is that when John got there, he went into the basement. Brian Higgins and or Brian Albert and or Colin Albert were there, and an altercation happened, including Chloe biting his arm, and somehow hit on the head or fell back and hit his head. Something happened, and he was dead. They didn't necessarily mean to, but that's what they think happened. And then the party goes on, everybody leaves, and then at, 2:30 or whatever, in between there, Brian Higgins leaves the party on the early side because everybody else stayed until like 2 a.m. He left around 12:45, if I remember correctly. Not long after John O'Keefe showed up around 12:30, 15 minutes or so is enough time for him to beat a guy up, Brian Higgins goes to the Canton police station from the Alberts house. He said in his testimony that he was doing administrative work and then explained that means that he was moving cars around. But Alan Jackson was like, what if actually, though, he was paying attention to, paying attention to see if anybody had heard about what he had just done, essentially, in Brian Albert's basement to John O'Keefe. Had any calls come in? was anyone, like, had anyone found a dead man in the basement. And so eventually Brian Higgins goes home from there. Brian Higgins is shown on camera at the police station around, I believe, 1:30 in the morning. So sometime in there is when he arrives there. He moves cars or whatever. He goes inside the building for a while. That's when he's caught on camera, at least around 1:30 a.m. So the time frame would have been wider. So next, Alan Jackson brings up, everybody disperses from the party. Nobody sees John lying on the lawn. There's a 22-second butt dial, allegedly, phone call between Brian Albert and Brian Higgins at early in the morning in the 2:20 a.m., 2:30 a.m. time frame, which is also the time frame during which Jen McCabe, in her own home, Googles how long to die in the cold, according to the defense. Again, I'm still annoyed about that evidence piece. And I don't think that that's necessary to prove the rest of the defense's case, because they're not saying that Jen McCabe was in the basement. Anyway, but they are saying that Brian Higgins did see somebody come in to the house at the time when everybody is saying, we never saw John come into the house. We never saw John come into the house. But Brian Higgins slipped at one point, Alan says, and said that he did see a tall guy with dark hair come into the house. I've been going back and forth in my head about whether he meant John O'Keefe or whether he meant Colin Albert, because right at the beginning there, Colin left. But the moral of the story is there's enough doubt there, right? There's enough doubt. I shouldn't be wondering what he meant, right? So there's that 22-second phone call that was answered. That was not a butt dial because it was answered. And then Alan presents that Brian Higgins went back over to Brian Albert's house, and the two of them picked up John O'Keefe, brought him out to the front lawn, and laid him there. And as soon as Alan said that, I was like, you really had me until then? Because again, why would you leave a dead man on your front yard? If you're going to move a dead body, why would you move it to somewhere else still on your property, especially in a very visible place like a front lawn? So that's where I'm like, I'm not necessarily sold on that part of this theory. I think that something happened outside where he was, because the medical experts said, whatever. Just, that's my opinions. We'll get there. But this is what the defense's case is. And then I guess they go their separate ways. And then again, Karen comes back with Jen and Carrie, and they find him there on the front lawn. And then everything else ensues that we have heard about all this time. And ultimately, the main thing is the injuries on John do not line up with the Commonwealth's theory of what happened. End of the day, that's that. So there's really nothing else to it. Like that scenario that they put forward is a scenario that the injuries do line up with. And the big theme of Alan Jackson's closing was look the other way. The Commonwealth is asking you to look the other way. There's all this evidence that what they're saying doesn't make sense, but they're just saying, look the other way. Look away from that evidence. Look toward the stuff that we like. Look toward our theories. And look away from Michael Proctor calling Karen Reed all sorts of terrible, nasty, sexist names, ableist names. Look away from the underqualification of their experts, like the accident reconstructionist coming up with a theory that is unbelievable at best. And just, the Commonwealth is trying to spoon feed to you this thing that, using your common sense, objectively does not make sense. So don't vote guilty, essentially, is what he's saying. And then we get to the prosecution's closing. Did I miss anything big from the defense's closing? Oh, yeah. Yeah, I think we're doing okay. Oh, thank you guys. I'm glad the audio is okay. All right. So then from the defense's no, sorry, that was the defense's closing. From the prosecution's closing, because they went second. The prosecution got up and started their argument with, I hit him, I hit him, I hit him, I hit him. And to me, that shows that those statements from Miss Reed are really what they're basing this whole case on. And back early in the case, there was a lot of doubt raised about those statements from Karen Reed. A lot of people say, she was saying, could I have hit him? Did I hit him? Was it me? Did I? Asking questions. There's a couple of people who said that she said affirmatively, I hit him. At least one of them has ties to the Alberts family. And I think other people heard it from that first person. Katie McLaughlin, firefighter, is the one who I think told other people that that's what Karen said. There's not really anybody else. Like, that's where that not rumor, but it feels like a rumor. That's where that originated from. And that's a very shaky ground on which to stand this entire case. So the prosecution goes back through the case that they've been presenting. They spent 8-9 weeks presenting this case of they were fighting, she was mad, they played some of her angry voicemails, they went through the timeline of she went to C.F. McCarthy's, she had 1 million drinks, she went to the waterfall, she had a couple more drinks, she went with John in her car over to the home of the Alberts. They were fighting, and that they believe that due to this one piece of evidence from the car data, that she reversed 62 feet at 24 miles an hour into John. And again, there's a lot of question around that car data because, first of all, it was interpreted by Trooper Paul, who was vastly less experienced than, I wish that the defense had called a car expert to, or had the accident reconstructionist address the car information, but, but also the specific car data that he looked at, the timing of it very possibly could have lined up with when the car was in the possession of the police, rather than when the car was, in Karen Reed's possession at midnight 30 in the morning. And the confusion about the timing of when that happened, and also the fact that the defense's accident reconstructionist described moving in reverse at 15 miles an hour is super fast. It feels really fast. So for them to then put forward, if that data exists in the car history, that at some point it reversed 62 feet at 24 miles an hour, I have to wonder, was it being driven by a person, or was it being towed, or what happened to make it go at that speed? I have a big old question mark around that. So they believe because they were fighting, Karen Reed backed into him at 24 miles an hour, hit him on the arm while he was holding his cocktail glass. It spun him with the force. It shattered the tail light, scratching up his arm. And this is where, and I'll finish the thought. And it threw him to the side about 30 feet. or he like slid or rolled or tumbled his way 30 feet from that, and along the way hit his head. And that was that. Lally said, you know, all of this conversation about the scratches on the arm and how it doesn't line up with being hit by a car. The placement of the scratches being on the posterior side of the arm, meaning the back of the arm, essentially. The this side, not this side. Outside of the arm, not the inside. He's like, we never said that his arm was outstretched at the time that Karen hit him, except that when Alan asked Trooper Paul that question, he said yes. So, yes, he did. And then Lally's like, and all of those scratches can be explained if you think that John had his arm up like this. So, like, the back of the arm is facing whatever hit him. But that also makes no goddamn sense, Lally, because are you saying, listen, I'm 5'11". I'm not too much shorter than John O'Keefe. If I stand on the side of the road with my arm up like this, what kind of vehicle is tall enough for the tail light to hit my arm up here by my shoulder, holding on to my shoulder, essentially, or having like my cup up here, like this is where I hold my drinking glass? Maybe if they think he was like doing this. What vehicle? Karen Reed was not driving a monster truck. Unless this car has, you know, some fairy dust and maybe it's alive and it jumps sometimes and it jumped its way up to hit my arm like this, and then that sent me back flying. But again, okay, guys, hold on. I'm so annoyed by this. Look at the alignment. Look at the alignment of a human body, okay? Once my arm is up like this, if that's what Lally is suggesting, that this is how the arm was positioned when it was hit. You know what else this is directly in line with? The entire rest of my body. My shoulder, my hip, my, you know, depending on how I was standing, perhaps my leg and my feet. Look at this line, the line that's created. Watch my arm as I stand up. Oh, there's my hip. There's the rest of me. The whole lower body that had nothing on it. Lal? Really? Lal. And this is where I get like, okay, so this is what I said before about like, the way that lawyers argue when they know that they're fighting an uphill battle. The defensiveness, the lack of confidence. He's throwing smoke, like he's throwing up a bunch of smoke and mirrors of, well, it could have been like this. But it's not your job to tell me what could have been. It's your job to tell me what was. And I feel like he's constantly playing volleyball with the defense's facts rather than, I don't know. Here's the thing. Both the defense and the prosecution asked for a continuance on this case, which means they asked for the case to be delayed and not to go to trial until after the FBI investigation concluded. The court said no. The court, being the judge, said no. I think, honestly, that was meant to be a way to tell Lally that you should just not prosecute this case. Because after the judge says no, it's up to the prosecutor whether to continue the case and bring it to trial with such shoddy evidence or to just drop it. Just drop the charges, admit that you don't have enough evidence to prove what you're saying. Therefore, what you're saying might not be true. Like, I'm so sorry. I know that you're probably very dedicated to this theory for God knows why, but it just might not be right. But rather than admit that he might be wrong, or drop the charges, do more investigation, and then recharge, which is a thing that you can do. You can't retry. You can't double well, you can. If it's a mistrial, you can retry, but like you can't, once somebody's been acquitted, you can't retry. You can't double jeopardy a person, but you can drop charges, do more investigating, and then bring the charges again. But Lally didn't do that. Lally has upped the charges over time, making them more and more intense, making it from her like accidentally hitting him with her car to no, she murder too. She intentionally hit him with her car and left him there to die, and then went home to his house for some reason and called him 53 times to knowing he was dead. Like, I don't, the behavior afterward does not line up to me with this theory. But yeah, so that's the rest of the theory, is that Karen Reed went home and just like went about her life. And Lally spent a lot of time bringing up, she did this thing that I don't like because she stopped talking to John's family. And she did this thing that I don't like because she went to John's house and got some of her things and then left, like later in the day after everybody found out that he had passed. Like, doing a lot, I think, of trying to establish consciousness of guilt, but really it's just like Karen was in such a panic. If you've heard those voice recordings, like voicemails and messages where she's screaming, she is out of her mind in a way of like, not like, oh, she's crazy, but in a way of like, she is in over her head. She has no grasp. She can't, she's inconsolable. She's beside herself. She's beyond herself. She's like in a pit of despair about this whole thing, which is also what leads me to believe that if she said the statements, I hit him, I hit him, I hit him, I hit him, it's because she was processing out loud. I think she was panicking. She was trying to figure out what might have happened. She figured out, like, essentially hearing from Jen McCabe, who was told by her husband, Matt McCabe, that they had been seen, driving in front of the Alberts' house. And so she's like, oh, that must be the last place that I saw him. And I dropped him off to go inside. And she's trying to put the pieces together because she's not a police. She's not an investigator. She doesn't know what happened, and she's trying to figure it out. And so she's asking, did I hit him? Could I have hit him? Did I hit him? And then she gets there and finds him dead. And so she's like, I must have hit him, even though I don't remember that happening. And you would notice, by the way, if you hit a human being with a car, an adult 6'2" man, you would notice. I don't think that she was actually like saying as a confession, this is what I did. And nobody around her treated her as though she was confessing to a crime. And I think that that's important to remember as well. So, yeah. What else even was the Commonwealth's closing? Was there anything that they said that I missed? Also, what was I just thinking? It was on the edge of my mind. It'll come back to me. I'm going to look in the chat real quick. I'm going to see what you guys are up to. And yeah, exactly. There are so many questions about her saying I hit him. Even if she did say it, I couldn't 100% hang my hat, I think is the phrase, on it being the truth. Yeah, exactly. I agree. Other people heard it. The question is if you believe them. A bunch of people said they heard it and then backtracked a lot. That's what I remember from earlier in the trial when they discussed this. I think that they heard it from each other, not necessarily from Karen's mouth, is my thought on that. But let me know what you remember. Okay. Thank you for the update. Jury sent a note to the judge to confirm they can leave at 4 o'clock today. EDB thinks they anticipate a full day of deliberations. So this is fascinating to me. Oh, this is fascinating to me. So this could mean a few different things. It could mean that the jury has a strong opinion. They just want to take their time going through all the evidence and make 100% sure. Or it could mean they're split. And split means Karen doesn't get convicted, they retry the case. But isn't it interesting how things look to us on the outside compared to the jury who's sitting there? I think that one of the things that Alan Jackson said in his trial, or in his closing, was you might not want to believe that the government has lied to you, or that the prosecution has lied to you during this trial, but that is what's happening right in front of your eyes. Like that kind of sentiment. I'm paraphrasing. And when I heard him say it, I was like, that's strong words, Alan. That's strong words to tell the jury that the prosecution has lied to them, has deceived them. And I think that that might be the crux here, because the instruction, I'll get to the jury instructions in a second, but whatever they have to find as jurors, they have to find beyond a reasonable doubt and to a moral certainty. That's the most certain you can be about something, where it feels right in your heart, essentially. Not just, I have doubts, but they're not reasonable enough to hold back this conviction. But like, not only do I not have reasonable doubts, I feel good in my heart about it, you know? And maybe getting to that is hard for people. I'm fascinated by that. Thank you. Thank you for that update. And yes, exactly. So about Karen's state of mind at the time that she made these statements, Caro J says, once Karen saw the blood on her hands and asked if she had her period, that tells me she is not thinking straight. You can't place value on I hit him. Exactly. She was not in her right state of mind. She, that is the kindest way that I can put how she was. She was not good. She was not fine. And she was not thinking straight. And this poor, oh God. Yeah, you guys are saying a lot in the comments that the prosecution is throwing spaghetti. This case never should have been brought to trial. I'm not convinced as jury. While we were on the prosecution closing. Oh, thank you. While we were on the prosecution closing, can I hat on the timeline? I think be mad about the timeline graphic for a second, because I'm not convinced the jury could have read a single word. Okay, thank you for bringing up the timeline. While the prosecution presented their closing, they presented a timeline of events, and I agree, it was far away from the jurors. The font was tiny, and I don't think that they could have read a word of it, but Lally was going through it and kind of reading it to them. An important point: nowhere in the prosecution's timeline do they list the time that they believe Karen Read hit John O'Keefe. So do they even think that she did? That's the most important event. That's the most important event of this. That's why we're all here. And you're not even going to put it on your timeline? This is how you know they're not confident in their case. This is how you know. They're not willing to put pen to paper and put it in writing. They're not confident enough to memorialize it on paper when they think that this shit happened. You know, does that not scream, we don't know? We're not sure? And if the Commonwealth isn't sure, how are we supposed to be sure? Yay. Oh my God. Yes, exactly, Slushy. Yes. Nowhere on the graphic did it say where she actually killed the man. Pretty important thing to have online at a murder trial. Yes. The timeline wasn't linear. The fact that... yeah, exactly. The fact that Lally was saying things like, Karen was calling him angrily as she backed up and hit him. So that must have been an overlapping time point in the timeline. I couldn't even absorb that whole mess because I was working a lot yesterday and I was trying to watch while I was in between moments at work, and I was watching on 1.5 speed, and there are definitely some things I probably didn't notice. Kate, I don't think the prosecution is lying per se, but they are definitely weaving a different narrative, which is the point of the court system and attorneys. Yeah, I mean, they are certainly weaving a narrative. I just wish it was a narrative that made sense. It just doesn't line up with the facts and the evidence, which is really hilarious because at the beginning of Lally's closing, he came out saying that the defense was trying to be selective about the facts that they were presenting, which, regardless of whether you're falling hook, line, and sinker for the defense's theory this whole time, I think it is completely fair to say that the Commonwealth has been selective about which facts they present. Even if you're on the Commonwealth's side in this whole thing, I think there are facts that they could have presented that they didn't, that they chose not to. Such as Exhibit A and B, the two FBI guys, and their two reports that were fully available to the state if they wanted to present them, but they didn't because they didn't line up with the state's theory. Ahem. Just saying. So that was really something to hear Lally talk about. And yes, Chanel. Initially hearing about this case, I was under a different impression. Didn't think it was an outright murder ever, maybe an accident. And that's how a lot of people are trying to approach this case. It's like, it could have, it could have happened, but probably it was an accident. I think that's how a lot of people went into this. That's how I went into it. It's like, convince me. But if this happened, I feel like it would have been an accident. And then they upped the charges to murder too. And they were asked if they wanted to provide an option for a lesser charge. And I think they said no. It's like it's all or nothing, murder or nothing for the jury to decide. And that might be contributing to why the jury is having a hard time and feel like they need a whole day of deliberation today. Oh, and interesting. So Chanel, I hope they have a copy of that timeline. Here's the thing. Demonstratives that are used during closing arguments are not given to the jury. Unless what they're demonstrating with is already in evidence as pieces of evidence, like Alan Jackson pulled up 2 photos of the tail light, and he mentioned the description of the tail light, which I noticed as well. Everybody except for Michael Proctor said that when they saw Karen Reed's SUV tail light, that it was cracked and had one piece missing. Michael Proctor is the only person who said that most of it was gone. And so Alan Jackson pulled up the photo of the taillight when it was taken a photo of in the Sally Port at Canton Police, and then the photo of the taillight as reconstructed by the science person, the person whose job it was to get all the pieces and put it back together. The way that it looked when it was reconstructed looked like what everybody else said. Cracked with one piece missing. Not what Proctor described. And so, like, those two images are separately in evidence for the jury to look at, but that side-by-side demonstration of them is not. That is something they're going to have to go back there and do for themselves if they want to. So, like, that's the difference there. But Lally's timeline, completely not a piece of evidence, and so that's completely not going to be back there for the jury to refer to. So yeah, it's very interesting. Thank you, Kate. My mom has MS, so I see the difficulties of it mentally, emotionally, but also physically daily. I think that needs to be acknowledged for Karen. Absolutely. Absolutely. Like, and I don't know much about MS, but I do know that it's extremely difficult to deal with. And that I think especially Karen operating on not much sleep and like being very stressed, like I really hope that the jurors like think about all of the factors when it comes to her state of mind that morning, because there's a very unsympathetic way to look at this case that also feels illogical to me. So, we'll see. Okay, I'm just looking through the chat really quick. You guys are great. Okay. So, yeah, I mean, from the beginning, Talking Bones, I would have noped out of it being clear when the red Solo cups and the leaf blower came up. How am I meant to convict someone with that evidence gathering? Yeah. There's been issues all throughout this case. There's no denying. And in a way, the Commonwealth doesn't deny it, but they do by putting this evidence forth in a serious manner. From an objective outside point of view, which most of us are, because most of us are not from Canton, Mass, it's bad. It's bad. It's bad. And I think that there's truth to IMO. Because O'Keefe was a cop, the Commonwealth felt pressure to take this to trial as a statement. Yes, I think that that's absolutely true. I also think that there's no statute of limitations on murder. So they could have waited until they had more time, or like more solid evidence, more solid proof. They could have dropped the charges until the FBI was done with whatever they're doing. And I feel like that's kind of what the court wanted Lally to do when she refused to continue the trial. I don't know. Okay. So let me just mention something about jury instructions, because so this is the juror experience, right? They hear the prosecution's case, they hear the defense's case, they hear both of their closing arguments, and then they get instructions from the judge about what they need to find, what conclusions they need to come to in order to conclude that Karen Reed is guilty of X, Y, and Z. And hold on. The charges against her, tell me if I'm wrong, because I might be wrong. I might be forgetting how the order. Murder 2, which is depraved heart or depraved mind, where you did an intentional action and that action caused death of the person. also DUI, essentially, so that's the first one. DUI resulting in death, or operating under the influence of alcohol that results in a death of a person. And then the third charge is leaving the scene of an accident. And that's the 3 charges as far as I know. Let me know if I said that right, because I believe I did, but I'm not 1,000% sure. So, first of all, the first thing I'd like to say is all 3 of these crimes being charged, in order to convict on these 3 crimes, you have to believe that John O'Keefe was hit by Karen Reed's car. And I just cannot get there. I really can't, especially with the last witnesses. Not only all of the defense witnesses, but even the last Commonwealth witness, the medical examiner, was not able to commit to the idea that John O'Keefe was killed due to being hit by a car. She wasn't even willing to commit to him being hit by a car, regardless of whether or not it killed him. So, like, I don't see enough proof, especially considering the timelines that the prosecution has put forward has changed quite a bit about when they think that this accident, this pedestrian vehicle accident would have taken place, has changed from like 12:45 a.m. to like 12:30 a.m. to like somewhere in there ish / we're not even going to put it on the timeline because it's so obvious that something must have happened in a certain time period early in the morning. So you just use your common sense. And so we're just not gonna write it down because you all know what happened. ESP or whatever, I guess. And so the medical examiner and every single defense witness, who, like I said before, are immensely qualified and immensely more qualified than the Commonwealth's witnesses, they all said they don't think he was hit by a car. So if you can't get over that, you cannot get to any of these charges. You really can't. And that's where I'm at as a juror right now. If I was a juror, I'm not. And then this is something I wanted to talk about as well. Thank you, Zara. I think murder 2 had the involuntary as a mandatory thing to also advise the jury on. So this is where I got confused, and let me know, you guys, if I'm understanding this correctly. So when you charge somebody with something, murder is a higher level charge than manslaughter. Manslaughter means that you have done something that accidentally kills somebody. Murder means you intentionally killed somebody. Sometimes what will happen is that the jury is allowed, instead of going with the more intense charge, murder 2 in this case, sometimes they're allowed to say, I don't think she committed murder 2, but I do think she committed manslaughter. I don't think that she did something to mean to kill him, but I think she did something that accidentally killed him. Like, it gives you an alternative if you feel like something happened there. And usually the sentence is lighter, although not very light in Massachusetts. But so when they were giving the jury instructions, they described I wasn't sure I wasn't sure if the judge was saying these are the options that you have and the various options you can find instead of finding murder 2, or if she was saying, in order to find murder 2, in order to convict Karen Reed of murder 2, you have to also say that she did these things. You have to get over these hurdles. One was homicide with a vehicle, which is the most basic charge, where
somehow you did something with a car that killed another person. That was like hurdle number 1. If you get over that, you have to also get over manslaughter with a vehicle, and that you did something either, you can't go with negligent, you have to go with reckless, that you did something recklessly by accident, where like, sure, you didn't mean to, but you should have known better kind of thing, which in this case would be like the drinking while driving, or the like not looking before you back up, and maybe that's how she backed into John or whatever. And so if you can get over the basic fact of I was in my car when my car killed a person, to I did the thing that caused my car killing a person. Even if I did it accidentally, it was reckless and I should have been more careful. I don't know if those are alternatives that the jury can come to instead, or if she was saying that you have to reach both of those standards in order to then also reach murder 2. It was intentional. I intended to do something, and that thing that I did ended up killing that person. Let me know. Because if there's options that the jury can say, well, maybe I don't think that she intended to murder John. Maybe I think that she just was reckless and hit him with the car. Or maybe I don't even think she was being reckless, but something happened where her car killed John while she was in it driving. Like those 3 different levels. If those are different options, then that makes for a much more interesting conversation back there as a jury. But if it's not, if it's just like, these are the hurdles you have to cross in order to reach murder 2, then that's important to know. But again, it all comes back to thinking that he was hit by a car. And a bunch of doctors just got up there and said that they don't think that, or they can't commit to that. So I'm looking in the chat. Isn't manslaughter also intent, but in the spontaneously in the moment, like without premeditation? That's murder 2, as far as I know. That's murder of the depraved heart, like a impulsive thing. I believe. I'm not a lawyer, but that's what I think. Yeah, so that's my hunch, my theory right now is, or my what? It's not a theory or a hunch. That's what I'm kind of trying to debate in my mind about how the charges are laid out. But at the end of the day, everything comes back to, do you think Karen Reed hit John with her car? Regardless of the drama, regardless of the why, regardless of the, like, the situationship between her and Brian Higgins, regardless of what she did after the fact, regardless of what she did before the fact, do you think Karen Reed hit John with the car? I don't. And I just don't think there's enough evidence to get us there. So if I was on a jury, just that would be my vote. But now I want to definitely open up the floor for deliberation. Oh, and you're right, Zara, absolutely. It's not even if we think she hit him, it's if we think the Commonwealth proved that she hit him. Good point, good clarification, absolutely. Even if I thought that she hit him, certainly I don't think that the Commonwealth proved it. If anything, they presented evidence from people saying that they don't think that she hit him with a car. So That really doesn't help. That really doesn't help. Yes, yes, Kate. Involuntary manslaughter which is one of the options, or one of the things you have to overcome, is like intentionally speeding and accidentally killing someone as a result of the speeding. Yes, thank you, Kate. That's a great example. Oh, my AC calmed down. So let's be a little internet jury here for just a minute, if you're willing. I hope that does anybody have any questions also? I hope I've like properly presented the wrap up of the defense's case. Oh, now I can, wrapping up the defense's case, pretty much summarizing the defense's closing argument, summarizing the prosecution's closing argument, and kind of telling you where I sit right now and the holes that I see in the stories. I think there's a plot hole in the defense's story around the Bryans just like bringing John to the front lawn instead of bringing John anywhere less incriminating. Like, I don't know why you would do that. And the main plot hole in the prosecution's case is like the whole case doesn't make any sense. But especially what they're trying to use about Karen's behavior afterward does not line up with the behavior of someone who just killed their long-term boyfriend. In my opinion, I don't see it. I don't see it. So I honestly, at the end of the day, my thought is I don't think that either side is right. I think that one of them is closer than the other in that, like, at least what the defense is putting forward, like looking at the injuries, could have happened, unlike what the prosecution is putting forward. But I don't know if either of them is 100% right. The person who has the burden of being right, of proving that they're right, is the prosecution, though, not the defense. And the defense has definitely raised enough reasonable doubt for me. Yeah. And the AC is back. I have it on a energy saver mode, so it turns off when it feels like the room is cold enough. And it just took that like 2 minutes before it turned back on again because the sun is just heating up this room. So it was absolutely heartbreaking to listen to her breakdown when she realized what had happened to John. Yeah. I hope, and I have to believe, that the jury feels the same feelings that we feel about, like, obviously this woman was in the most distress of her life. And it can't, that doesn't lead to knowing statements. That doesn't lead to like a willful, knowledgeable confession. It leads to panic. You know, like, poor thing, in my opinion, you know? So, interesting. This is a good point, Zara. So, I would say they proved Proctor's messages are indefensible, but Lally managed to follow up with that in closing a bit. So, yeah. I think... Yeah, so Lally was saying, like, listen, we have to be nuanced here. We can hold two things at once. Yes, Proctor said very nasty, indefensible things. Also, Karen hit John with her car. And I'm like, I see what you want to do here, Lal, but I don't think that you can in this case. Because it wasn't just Proctor saying, oh, she's a B word, C word, slutty, this and that, you know, and looking for her nudes. It was also him saying the Alberts aren't going to get any shit because they're a Boston cop. We're going to... He didn't exactly say we're going to pin it on the girl, but that was what Alan Jackson kept paraphrasing it as. But something along those lines. And so if it was just Proctor, you know, having issues with Karen's character as a person, that's one thing. But he was talking about the case. He was talking about, you know, coming to a conclusion. He said on the stand, the rush to judgment. He came to a conclusion by the end of the first day. And then they went forward based on that initial conclusion. And that was not something that Lally addressed. Like, there were parts of it that Lally addressed and parts of it that he did not, that I feel like he needed to, in order for me to believe a word that Proctor said. And no matter how much Lally could have defended Proctor, I still would not have believed a word. Not a word, but like, I would have had a real hard time. Exactly. Him concluding what happened after 16 hours when none of the medical experts were confident to conclude anything. Exactly. He just decided, I think this is what happened, and so that's what happened. Yeah, exactly, Captain. I think the thing with Proctor that sticks with me is he's not going to get any shit. He's a cop. He's a Boston cop. Yep, exactly. Yeah. Slushy, I want to answer your question, but I don't know what it is in reference to. But did she? Let me know. If it's, or it might not even be to me, because you guys are having a lovely conversation on your own. Oh. Yeah. You know what else? The prosecution never explained the placement of John's phone under his body. Like, the accident reconstructionist was like, yeah, it just must have fell out of its pocket and landed under his torso. Like, what? Tell me more about that. If you think that this is what happened, tell me more about that. Because that's another thing that's like, the only way that could have happened was if somebody put him there with the phone under him. Or, you know, however he got injured at the end of the day, which, like I said, I'm not confident that the defense is right. I'm definitely not confident that the prosecution is right. If he was like standing there holding his phone, maybe he was out there trying to call or text Karen so that she could come pick him up, and then he gets fucking walloped on the back of the head and falls. You know, he's immediately unconscious. He falls over, and the phone is like right under his chest or something. I don't know. And then a freaking coyote comes out and chews on his arm. I don't know. But like, there was so much stuff that just kind of got glazed over with 8 weeks of testimony. I have like material questions like that. Like, and I'm no professional, okay? I'm just a lady, and I feel like that is a question that I have that I feel like needs answering before I can understand this. It's not so much that Karen is innocent, but more so she's not guilty of these charges. I think as far as what they've proved, for sure, I don't think they've proved that Karen did anything. That's the problem. Like, even if it's not these charges, like, I don't know what charges she would be guilty of based on what they've proved, because they haven't proved shit. At least not shit that matters, you know? But if you have an idea, let me know. Like, what do you think the Commonwealth has proved that, like, is there anything that Karen might have did Besides the DUI, she probably, yeah, you could probably get her, you could probably get the whole family, you could get the whole neighborhood that showed up that night on a DUI. Like, other than that, I don't know, man. I don't think they proved that John was hit by a car, and I don't think the defense proved their side either. Yep, though they didn't need to. If anything, I could see it being a drunk boys club mentality. Yeah, honestly. There's a lot of options. Yeah, right, exactly. He was texting on his phone with his arm bent up, so the phone was 3 inches from his face. Maybe. Sure. There's confirmation bias, and then, well, and that too. There's confirmation bias, and then there's the taillight pieces appearing weeks after the fact. That too. We never really got to. I didn't think that we were gonna get anyone admitting that they went and planted those taillight pieces. I didn't think we were gonna get anyone admitting that. But Alan only asked Proctor. And Proctor obviously said no, but I kind of wished he would ask some of the underlings. Because if anyone was going to be more likely to say yes, it would have been the underlings. Also, can I just say, okay, once again, who is the one that first decided that Karen was hit by a car? No, that Karen hit him with her car. Does anybody know? Because Michael Proctor and the state police was not the first people on the scene. Canton police was the first people on the team. They told Proctor that they thought Karen hit him with the car, if I remember correctly. So who on the Canton team decided first that that's what happened? I don't even know what is the origin story of this theory. Like, after 8 fucking weeks of the prosecution's case and their closing argument, maybe that's why they didn't put on the timeline when they think that Karen hit him with the car, because they don't know. They don't even know whose idea it was that that's what happened. Like, okay. Jen McCabe, most comment section / people I've seen theorize that it was Jen McCabe. And, but maybe, I guess, because Link, I have to think way back. We got to go way back in time here. At the beginning of the trial, they were interviewing the Canton PD people, and Canton PD included Officer Lank and Seraph and maybe somebody else. I think it was Seraph. And then he called Lank in, and they interviewed Jen and Brian Albert and Nicole Albert all together in like the kitchen. And like they did like a quick conversation. Lank, remind me, tell me if I'm wrong. Lank went in and did a quick chat with them, and then more officers went in and they interviewed them separately. And then later in the day, also, they were at Jen McCabe's house and did, oh, good. Yes, thank you. Yes, that's what happened. Okay. There was also Sergeant Good. Okay. Sergeant Good. And then they called in Lank. Okay. So Sergeant Good and Sergeant Seraph went to ask if they could go to the Albert's house. They had a quick chat. They called Lank, and then they interviewed people separately. And then later thank you, AC. And then later in the day, they went to Jen McCabe's house and held more interviews there. And that's when Carrie Robert was interviewed. Or like, no. That was like a week later that Carrie Robert was interviewed at Jen's house. So the first interviews, essentially, other than Karen running around and like saying a lot because she was panicking, the first interviews were with Jen, Brian, and Nicole. And Nicole and Jen are sisters. Brian is Nicole's husband. He's the Alberts, whatever weight you want to give to that family name. So if in those original interviews, Jen said that, thank you, Scarlett. The origin of the idea was Jen McCabe changing Karen's "did I hit him" to "I hit him." And that could be what it was, is that in those initial interviews, Jen had the idea that because Karen was asking about it so much, she had hit him with the car. And so then they took it and ran with it. But that's not, so then that would have essentially means that like, just because somebody says something doesn't mean that it's true. So like, but once a police says something, oh, Lauren, sweet Lauren, there's so much to discuss. Please help Lauren out in the chat. Witnesses can say what they want, but once a police repeats it to other officers, that like validates the story. You know what I'm saying? So I feel like there's a combination there of, if Jen McCabe kind of had this idea, and she had been with Karen all morning, so it makes sense that would be a potential source, combined with the credence being given to that idea by Saraf and Good, and then they tell Lank, and then they get into a process of confirming what Jen said rather than putting it on a list of many theories and investigating objectively. Does that make sense? So I feel okay. So thank you guys for helping me work my way back to this, because God help these jurors trying to piece together why the Commonwealth even thinks what it thinks. Yeah. Oh, right. And then poor freaking Karen. They had her, I forgot, they had Karen 5150s essentially, but like they put her on a psychiatric hold at the hospital, which is obscene to me, that a woman who is obviously grieving, keening over the loss of her boyfriend in a mysterious and violent way needs to be on a psychiatric hold. Shut up. Shit. Bullshit. Anyway. It's pathetic. She's a hysterical woman being hysterical. Oh. She must be guilty of murder. But also, the first responders had no idea what happened when they arrived, and the first thing they hear is a woman saying she might have hit him, and that's what they recount to the police. That's true. So there's a community feeling, essentially, from a lot of people there that, she keeps saying this. But again, it's like, what credence do you give? Like, how much weight do you give to that statement from a woman who is clearly lost it? She has lost it because she's so overwhelmed by, like, I'm just surprised. I'm just surprised. All the more reason we need some mental health education among police departments, as well as just in general in society. Because, like, when you're in a panic, when you're in that situation, Like, I'm so sorry, but you're likely to say some things that you would have later taken back. Or you're trying to process out loud. Some people process out loud, which honestly I think that Karen might be that kind of person just because of like the history of her like wanting to talk things out a lot. She's not the person who's going to take some time, go be by herself, think things through, and then come back when she has a problem and like calmly address it. She's like, no, we need to talk it out together now because now. So I think that she's trying to talk it out there in the moment because what an absurd situation to find yourself in suddenly, you know? Absurd is the wrong word, but like you never would have expected, you know? Terry, I don't have Emily's post. I don't have Emily's app. Can you please let me know? Is the jury back? I'm refreshing. I see verdict watch. Jury watch. Let me see, because a lot of times the app notifications also are the notifications that she'll send out to the Instagram group. So let me take a look at that. I don't have that. I'm looking at Emily's story. Karen retrial is with the jury. Hold on, stop. Hey, jury out. Oh, no, this is old. No, go back. The court has. Stop it. Okay. The jury's not back, but there was an argument that on the manslaughter part, they did not put not guilty, and they are fighting that there's apparently not an option for not guilty on the forms on the lesser included charges. Oh my God. That's so annoying. Oh my God. I hate this shit. Oh my God. Okay. All right. Well, here's what. Let me do something really quick that I can do, which is I'll screen share. So this is Emily's Instagram story from earlier. The Karen Reed trial is with the jury. They typically end at 4:30 p.m. Eastern, but the court said she would ask them if they would like to stay longer at the end of the day. I'll keep you posted in the Law & Order app. I do not have the Law & Order app because I have too many apps. But now if I'm going to be doing court coverage, I probably should get it. And so then this is the update of the morning so far. Thank you guys for keeping me posted, because I do, with my ADD, I try to stay away from notifications while I'm streaming so that I don't get too torn. So Emily just posted about an argument about the verdict forms, and the jury is not back, but there was an argument that on the manslaughter part, they did not put not guilty, and they are fighting about that. So on the verdict forms that the jury needs to put out, or that the jury needs to fill out, there needs to be a guilty and not guilty option for each of the things that the jury is supposed to find or not find. And it sounds like they're saying there was no option provided for them to say not guilty for the manslaughter charge. So I don't know. I'm curious to find out who figured this out. If the jury came out and said something about it, or if Jackson noticed it, or Lally, or Yannetti, or who, and how they're going to remedy that. But I don't. This is not going to cause a mistrial. You know, this is just going to be clerical error, in my opinion. I don't know. I'm just predicting. I think clerical error, fix it and move on is my hope. But verdict forms are extremely important, and jury instructions. So sometimes there's things like this can cause really big problems. There's apparently not an option for not guilty on the forms on the lesser included charges. So maybe it's more than one. Maybe it's not just the manslaughter charge, but also the homicide with a vehicle charge that doesn't have that. Defense has problem with jury form. Okay, so Sammy. Okay, so Sammy copied the actual update from the app. Thank you, Sammy. I should just get the app. I should be ethical in that way. Right after 10 a.m. on June 26th, the first full day of juror deliberations, Alan Jackson asks to put a matter on the record. He said to the court that the lesser included charge verdict forms needed to include an option for guilty or not guilty, and the forms, I guess, just have a guilty option. The court assures Jackson that this is how it's always done in Massachusetts. Why? And he responds, also in Massachusetts, fuck off this judge. No wonder Jackson is making such a point about, like, it's the community is protecting itself and protecting their police, and the cover up in the community, the Canton PD, because the judge keeps making this point. I've heard through the grapevine in like pretrial hearings and stuff about, like, well, here in Massachusetts, Mr. Jackson, this is how we do it. And I'm like, he's from California. He's not from space. Like, can we just chill? We're all Americans, aren't we? Like, can we just chill? My God. Anyway, so Jackson responds, I don't really care how it is always done in Massachusetts. I care if it's appropriate. Naturally, the court interjects, I assure you it's appropriate. Jackson says, how do they decide she's not guilty of the involuntary manslaughter? Referring to the fact that both the lesser included for involuntary manslaughter and motor vehicle homicide don't have not guilty options in the form. The court indicates that the jury doesn't have to check anything, and that indicates that they wouldn't be finding her guilty. Court states, that's how it is, Mr. Jackson. He responds, apparently that's how it's going to be based on the court's order, but that's not how it should be, and it's over our strong objection. He then argues that if they come back guilty on a lesser, it's immediately appealable. I agree. The court turns to Yamato and says, Mr. Yamato, you've seen verdict forms like this, but he indicates he hasn't even on lesser included charges. He hasn't, something like that. And then you can see Karen Reed shaking her head, and the court interrupts. Excuse me, is this funny, Miss Reed? All right, we're done, and walks off the bench. Oh my God. I've never seen a verdict forms without both options. However, if this is the regular practice, it will have been addressed by Massachusetts courts. Stay tuned. Weird. What a weird thing to double down on for the court, in my opinion. Like, there's no reason to not just provide, like, just real quick retype the forms, and or like, you don't have to retype the whole form. Go in and add a little checkbox for not guilty. I agree with Alan that it is absolutely immediately appealable if they don't do that, but also, again, what a weird thing to double down on. Also, I do take issue with If Karen Reed is shaking her head and the court says, "Excuse me, is this funny?" I'm so sorry. Shaking my head is not laughing, Your Honor. Just in case you're unfamiliar with human interaction. But anyway. Yeah, it was Jackson that brought it up. Yeah, thank you so much, Sammy. I really, really appreciate it. I agree, Zara, with all the effery that's alleged. I don't know, all the fuckery. I can say fuckery. You would think they would think to double check it all and make things bulletproof. If this is just how it's done in Massachusetts, then I guess they don't have to. But I think they should. Like, if there is the implication of only having an option to check off guilty is an implication that she is guilty. I think that's what would be argued. And I don't know if I necessarily agree, but with how things go in courts, they're just like super literal, super covering their bases all the time. Sorry, guys. So thank you, Sammy. Earlier when I was reading Yamato, apparently it was a typo of Yannetti, who is another defense lawyer. Thank you so much for clarifying that, Sammy. What an interesting typo choice. So with court usually being so, like I said, so literal, so direct, so covering your bases, like explaining things to the nth degree that you think like maybe you don't need to explain it this much, but they do. That then I would think they would provide for the lesser includeds. But I guess okay, so you remember before how I was saying that I wasn't sure if the lesser includeds are independent options that the jury can alternatively choose instead of choosing guilty on murder 2, or if they were like steps on the stairs that you have to scale in order, or like hurdles you have to get over in order to reach murder 2. I think that is what I think that's why they only provide a guilty option. If it's like, first you have to find her guilty of vehicle homicide, then you have to find her guilty of manslaughter, then you can find her guilty of murder 2. But that, I don't know, because the whole point, manslaughter and murder are two different things. One is intentional, one is not. So you can't find her guilty on both. So I don't think that they're hurdles like that, this plus this equals this, you know? Okay. My theory is no. And I'll just bring up, this judge was literally asked to recuse herself. There is, I was not watching the pretrial hearings, but from what I hear, she has a brother that's involved with somebody somehow. I don't know. So judges being asked to recuse themselves is very interesting because the judge gets to decide usually whether or not they should recuse themselves, which I think is a little silly. But if you've been watching the business going on with the YSL case with that judge, oh my God. And he keeps, there keep being motions for him to recuse himself. And he keeps saying, no, I have judged, I have decided, and I have found the facts that I am not biased. So I'm like, sir, anyway. Okay. Yeah, exactly. Unnecessary complications to an already stressful and sometimes confusing process. Always confusing process. Yeah, according to NBC Boston and Canone, I don't know, Canone. Canone is the judge. Thank you, Kate. If you don't mark guilty, it gets read as not guilty. So yes, but I also think that I agree that there's the who said it? Scarlett, if they give jurors a stack of documents with only guilty checkboxes, wouldn't that suggest to them that they're supposed to check at least one? Yeah. That's there's an implication there, or at least there could be an argument that there is an implication there, even if that's not intended. Oh, jeez. Thank you, guys. The judge's brother represented one of the Albert brothers on a case, DUI, I think, and her dad or brother might have been the lawyer for a Chris Albert DUI case. Okay, so one, I'm not surprised that DUI runs in this family. Secondly, I don't like that as a... I don't know if it rises to the level of being a conflict, but it's not a conflict. Like, I feel like it's close enough to muddy the waters. I don't know. Okay, Legal Bites has a copy of the jury form. Thank you, Marie-Louise. So if anybody... Let me go actually take a look. Legal Bites, who also has been doing some great coverage of this case. So let me... I'm going to screen share this so we all can see. Hi. Okay, there we go. So let's take a sweet little look at this. I'm gonna... Can I... Oh, I can zoom in. Look. Wow. Okay. Hold on. I zoomed in too far. I did too much. So Legal Bites. Love... oh, God. Legal Bites, fantastic channel. I recommend that you go subscribe. She posts an update that's essentially the same... the same thing that we've read, but I'm going to read through it because I want to give Alita proper credit. So she says, okay, there's been a question that came up about this verdict slip. Jackson argued with Judge Canone in court that each of the lesser included offenses should have a not guilty option as well as a guilty option. She says this is a normal thing for Massachusetts courts. He says regardless, it should be changed. Gennady also says he's never seen it done this way when he's tried cases with lesser included offenses. That's interesting, isn't it? Especially considering that this is a murder case, so it's a little, a little more... you want to really dot your I's and cross your T's. Basically, Jackson's argument is that the way it's currently written puts a thumb on the scale, exactly, in favor of conviction for the lesser included offenses. Now that I can see what the form looks like, I am actually less concerned about the jury getting confused about this. Basically, it looks like jurors' answer here. Is KR completely innocent of all possibilities under this statute? Or is KR guilty of any of these three options under this statute? Pick one of the four. The formatting of the four options puts them all on an equal line, which is what makes it less concerning to me. I think a juror can read this and understand that they have the option of choosing not guilty for this entirely for this charge. But if any attorneys disagree with me on this, feel free to chime in with your 2 cents. So, and that answers my question as well of it's not about building blocks to reach murder 2. It's about, instead of murder 2, is she maybe guilty of manslaughter or vehicular homicide or yeah, something like that. So now I'll zoom in a smidge. Commonwealth versus Kerrigan Reed, verdict slip. So now we can really be the jury. We can really see. So offense 2, manslaughter while operating a motor vehicle under the influence. In the above entitled case, we the jury say that the defendant is 1, not guilty. 2, guilty of the offense as charged. Manslaughter while operating a motor vehicle under the influence. Check one or both of the following, which means if you find, I believe, well, okay, whatever. So check one or both of the following, either or, and or, I guess, manslaughter while operating a motor vehicle under the influence of alcohol, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. 3, guilty of lesser included offense, involuntary manslaughter. Or 4, guilty of lesser included charge of motor vehicle homicide, felony OUI, liquor, and negligence. Negligence! Okay. Check one or both of the following. Motor vehicle homicide by operating a motor vehicle under the influence of alcohol, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. This is the unanimous decision of all 12 members. So I can see what Alita is saying. This form is asking you to choose what she's guilty of, or if she's guilty of nothing, choose not guilty. So that's interesting. I would be curious to see what the other, like if Yannetti has never seen a form laid out like this before, I'd be curious to see what he has seen as the alternative option to this. But this is what the jurors have received, and this is what the controversy is over. So now that you guys are seeing it, what do you think? What do you think? No! This one. I like that one. I think the idea is they have to check one and only one box. So if not guilty on all charges. Yeah, essentially. That's what I think. Yeah. Do we know if one of the lawyer jurors made it on the jury? I don't know about that. Hold on. Okay, this doesn't seem as bad now. Makes more sense. I don't love this form, but at least not guilt is the first option. Yeah, seeing it makes it a little better. It isn't as bad as feared, but if Yannetti had never seen this, it still feels a bit off. And I agree with that. I wonder what the other options are. So yeah, that seems to be the consensus, is that it's not as bad as it might have seemed, but it makes sense that Jackson argued this. He's a zealous advocate for his client, and anything that could be prejudicial is important to bring up. The numbered list is misleading because the numbers aren't actually listing the charges. They're the options overall. Okay. Interesting. I think they're the 4 different options that the jury can choose from. But I don't think these are like sub options under. You see at the very top, it says offense 2, offense 002, manslaughter while operating a motor vehicle under the influence. That's the charge number, I believe. And then these are like kind of your answers or your response, your verdict based on that charge, and you choose which option, I think. But if it's misleading or confusing, good to know that's the thought. I think it's fairly clear, but if they read out the verdict like I've heard in other cases, I do find it weird. We, the jury, find the defendant on the count of X, guilty or non-guilty. On the count of Y, guilty or non-guilty. Yeah. Also, the lawyer-juror thing, apparently 2 of the potential jurors are lawyers, and I wondered if we know if they're among the ones that actually now make up the jury. That's interesting. That's interesting. Here's, somebody has talked about that. I want to think, I've said in the past, like, I don't watch a ton of Kurt on Uncivil Law, but I think that he mentioned this in one of his clips that I did watch, where he's like, I'm a tax lawyer, so I'm not the type of lawyer that they would keep out because I don't do trials, I don't do criminal law. So maybe that's it, is like it depends on, like, another criminal attorney, like a criminal defense attorney or a criminal, like another prosecutor, like that I think would be more of the type of guy that you want to keep out, more of the type of lawyer you want to excuse. But if it's like a real estate attorney or, you know, something unrelated, then I can see. But that's still a lot of knowledge. That's still a lot of knowledge to bring in. I don't know. That's interesting. All right. So we didn't exactly like hold deliberations today, but I don't know if we really needed to, because I feel like the general consensus here today from our chat has been we don't think that the Commonwealth proved their case. Anybody watching on the replay, if you disagree, let me know in the comments below why. Yeah. But yeah, I feel like, or if you're here in the chat now and you disagree, let me know in the chat now. I would love to discuss, because I'd like to hear a compelling argument from the other side. I don't think that Lally presented one, unfortunately. But if there's someone out there in the internet jury, essentially, who does see it, who can connect the dots that Lally didn't connect and that I'm not really seeing, let me know. I've been trying to figure out how to put up a poll through, I don't know if it's through StreamYard or through YouTube. But anyway, I'm going to just take one last look at YouTube to see if, like, if there's any movement on the jury, but I don't think there's going to be. Actually, Lawyer You Know is about to stream on the jury form dispute. So here's what I think I'm going to do. I think I'm going to wrap up within the next couple minutes. And if you're curious for more content about this, Lawyer You Know, I recommend that you watch him. Yeah, this is a good summary. I don't know that JOK, John O'Keefe, was even hit by a car, any car, never mind who was driving. Dr. Whackjob, the medical examiner from the Commonwealth, and the Fed experts didn't make it sound like his injuries were consistent with vehicle strike. And I think that that's what the jury really has to sort through, is trusting the science, the data, the hard, unfeeling data that says this doesn't make any sense, versus trusting people and their feelings and their emotions about the circumstances and about this is what we think might have happened based on their relationship. This is what we think might have happened because she said I hit him while she was panicking. This is, you know, my feelings, essentially. It's a facts versus feelings kind of case, the way that it was presented. And I feel like the facts bear out in the direction of not proving guilt. I really don't think that the facts that we have prove guilt. So yeah. Let me know if you disagree in the comments below. Thank you so much to those of you who hanged out. Thank you, AC. Wow. Thank you to those of you who hung out for this nice morning live, 2.5 hours. Don't mind if I do. And oh wait, let me see. To have an right. Exactly, Chanel. To have an I think this is what happened from the prosecution, or like the accident reconstructionist, this is what is possible. This could have possibly happened, when it's their job to provide the facts, prove the facts of the case, is wild. I agree. So yeah, we'll see what the jury chooses, but I'm going to head out. Lawyer You Know starts in 3 minutes, talking more about the jury verdict form. He's going to have a lot more informed things to say about it than me. So I'm going to let you go listen to him. Thank you, Scarlett, for bringing this up. Thanks to the crappy investigation, John's family will never know, and that is just awful. We have to remember there are real people's real lives happening here. This is not just a story that we're following. This is real grief and real death of a real person. And I agree, it is absolutely awful that, in my opinion, I don't think the family is going to know what actually happened. I don't think any of us are going to know. Maybe when the FBI investigation is done. But the FBI investigating the investigation does not mean that they're investigating the death of John O'Keefe. It's different. So thank you for bringing us back to earth on that, Scarlett. Have a great morning, everybody. And I'll see you on Friday for some kind of a stream that I feel some kind of way about. All right. Have a great one. Peace be with you always. Like, subscribe, and turn on your notifications. That's what I got. Bye.